Good afternoon, everyone. Thank you so much for joining us. I can see we've got around 32 attendees and we've got a lot to fit into the hour, so we're going to make quite a prompt start today. My name is Ella El-Gabali. I am the Head of Knowledge for RICS Matrix London, and we're really pleased to be joined today by Dan Cooke, who is an Associate in Health and Safety for Rider Levett Bucknall. Dan's going to be taking us through the Building Safety Act, some of the updates that have been incoming and are still incoming by the sounds of it, Dan, over recent months and days. And he's going to talk a little bit about how this affects the wider built environment and all of our job roles as professionals within this field. You will see as you logged in, you should have got an automated message. The automated message should explain to you how you can submit questions through the chat, and these will come directly through to us. Because there's so much to fit into this webinar, we've said that at 1 p.m. we will extend for 15 minutes for anyone that would like to stay and have their questions asked or answered, and myself and Dan will stay on for that 15-minute period to answer any queries you may have. So without further ado, I'll hand over to Dan, and thank you so much for joining us again.
Great, thank you, Bella. Thank you for that, and welcome to you all. This is going to be a very brief high-level overview of the Building Safety Act, and I guess that opening question there is for you all. Are you all ready personally, and are we ready as an industry? So without further ado, we'll make a start. Just a brief agenda. As you can probably see, it's just obviously introduce the presentation today. I'll set a bit of context and background to what we are aiming to cover. We'll be looking at obviously the new statute itself and the associated legislation, how the legislation will be implemented, and then some questions that will be posed, really rhetorical questions posed to you through the presentation, and then if you want to pick up any at the end, I'll be happy to do so. So who are we? Just a brief overview of RLB. I say it's a pleasure to be presented to you today on this platform, but we'll dive straight in as we've got plenty to cover, as Bella said. At RLB, we are a global quantity surveyor and construction consultancy, providing management and advice throughout the built environment, working across all types of projects, from minor refurbishments to major complex regeneration, with CDM and fire services making up some of our core services. We were heavily involved in the drafting of the 2007 and 2015 CDM regs, and were named as APS Duty Holder of the Year for a project in Manchester, Circle Square, back in 2019. We were the first professional consultancy to complete the CIOB Level 6 Diploma in Building Safety Management, en masse. I was in that initial cohort, and it was pretty testing, but we got through, thankfully. And we're also a registered signatory of the Building Safety Future Charter, which basically means we are working in line with their principles of creating a positive culture and behaviour change in the built environment, helping the industry to develop the necessary leadership and culture that's needed to ensure people's safety is put first in how buildings are designed, built and maintained. This Building a Safer Future, you'll hear much more about it in the press and the industry going forwards. It was developed by a group of early adopters of these principles, such as contractors, housing associations and local authorities, who actually shared that vision, which came out of the report, the inquiry following the Grenfell disaster, of putting industry or gathering an industry together which is committed to putting people's safety first. So it's designed to drive the systemic change that's needed to ensure buildings are safe for those who live and work in them. And Dangerous and Hackett itself, along with the Industry Safety Steering Committee, have said the Charter is leading the change required for industry. So it's great that RLB is part of that, and you'll hear much more of that in the press and industry going forwards. So a little bit of scene setting. Before we actually go any further, I just want to pause here and just pose those few questions to yourselves. Like I said, they are rhetorical. If you have any concerns at the end, happy to go through them. But these are the kind of questions that we need to be asking ourselves individually of our own organisations and as a industry, as a wider sector. We are first to admit and highlight that the current situation is very much incomplete at the moment, given the fact the Building Safety Act was obviously launched last year, and parts of the secondary legislation are beginning to drift forward, but it's very, as I've said, incomplete and imperfect. situation at the moment, but it's all moving in the right direction. So any questions you do have for yourselves, for your own teams and organizations, and for me, if there are any at the end, I think they're a healthy thing. That's what we should be doing, raising questions and challenging what we've done before and how we can actually do things better. So as you'll probably be aware, the new legislation is actually has been introduced in response to the tragedy at Grenfell, where a fire broke out from one of the flats, causing the building to burn for 60 hours. 74 people lost their lives, including a stillborn baby and 15 of Grenfell's 37 disabled residents. It followed a similar incident 8 years earlier at Lacknell House on the 3rd of July in 2009 in Camberwell, in which a fire spread through a number of flats in the 12-storey building, causing 6 people to lose their lives. And if we just look at those numbers combined, and then obviously expand those numbers to represent their families, the community, lost loved ones, and the hurt, this clearly going to transcend a generation and more. It's something we've got to do right and do better going forwards. So this report, known as the Building Safety Future, hence the charter, the name given to the charter I've just touched on, was the final report that was issued by Dan Cooke and the review team, which outlined a new approach to managing fire and structural safety risks in high-rise, multi-occupied residential buildings. Oh, pardon, I'm not sure what's happened there. Bear with me, sorry about that. Not sure how that's happened. Have the correct slide. I'm sorry, it keeps jumping back. Bella, can you see the right slide I'm showing, the Building Safety Future slide?
It is correct, yeah. It's just not on share mode.
Right.
So I think if you press on the bottom right corner, there's 4 icons. If you click the one on the far right, it should play.
Dan, you can also click this button from current slide on the left upper corner.
Oh yeah, that's really easy.
Perfect.
That's right. It just jumps back. Okay, hopefully that's static for you all. So I do apologise. Of a gremlin in the system there. So I was just saying, sorry. So this was the report that was launched following the inquiry review into the disaster, and it basically represented the problems in the wider industry. Overall, 53 recommendations were made for government and industry to drive the cultural change and behaviours that are necessary to improve building safety going forwards. A catalogue of failures and missed opportunities were identified as part of the view into building safety. And as you can see from those quotes there, we're talking about a root and branch reform that was necessary because the system was designed was in summary broken. Some of the comments you'll see there included ignorance of legislation and guidance. So in some cases, hadn't even been read and certainly not understood fully. There was a indifference, quick and cheap, race to the bottom type motivations on projects, a lack of clarity on roles and responsibilities across the piece, and generally a lack of regulatory oversight and enforcement of the regime, of the previous regime. So that's where this new piece of legislation has come from. As you can see, it is set to be one of the most significant pieces of legislation affecting the construction and property management sector for over a decade. It's brand new. It requires a real gear change across industry, and that's going to be at an individual level, organisational and industry level. It'll introduce new secondary legislation, some of which we'll touch on later, and it's going to be largely centred around the residents and those other building users, whether they are contractors coming to do fit outs or future maintenance, and everybody uses the building because these are the people that we need to protect. And I think it was quite telling that the regulator was really keen on ensuring that industry understands that this is about the residents feeling safe in a building, as well as being told that you are in a safe and compliant building. So they're going to form a real real part of the heart of the drive by the regulator and the industry, because ultimately it's designed at protecting the safety of people, which is something I'm sure we all want. So in a nutshell, this new legislation has been designed and structured to address the historic problems which led to Grenfell and other disasters. Just a brief note here on the devolved matters, which building safety is one. This is we'll have regional differences across the UK. As you can see from the slide, just going from left to right, it is understood that at the moment, Northern Ireland are planning to introduce the Building Safety Act or parts of it. They're not there yet. So at the moment, any projects underway in Northern Ireland and being planned will need to be carried out under the existing regime. In Wales, they are implementing the Building Safety Act with a few minor differences from England. They've introduced a categorisation system. So in Wales, buildings that are 80 metres and above, they are classified as Category 1, and those that are below 80 metres will be classed as Category 2. And it is understood that they also intend to use a building safety manager as a key person to help manage these high-risk buildings. A definition we'll come on to shortly. In England, the Building Safety Act and all of its subordinate legislation will be implemented in full. So everything we covered today will be introduced in full in England. And in Scotland, because they have again another different systems in force there, it's understood there's going to be a little change at the moment. Maybe some focus on culture and just general improvement in competency. That's the Building Safety Act in a devolved matter level. So what's new? There are a number of new provisions, but the first thing to state and to make clear to you all is that the Building Safety Act will apply to all buildings, but there will be specific focus and actions on high-risk buildings. We'll come on to that shortly. A new gateway system has been introduced. There'll be 3 gateways for projects that are in scope, i.e. those that are classified as high-risk building. New duty holders have been created, and this is to make people more accountable. This is one of those driving changes of the previous few slides about changing and improving the industry. We need more accountability, so therefore we need to give new responsibilities to these new duty holders. They are the Building Safety Regulator, accountable person, and principal accountable person. And we should just make it really clear at this stage that whilst the Building Safety Act is live, the CDM regulation 2015 are running in parallel. So one doesn't trump the other, the two are operating in parallel. So please ensure that CDM continues to be applied on all your projects. Okay, this slide, as you can probably tell, will help us understand that definition of high-risk building. There is use of other terminology in use at the moment. High-rise building, high-risk rise building, they are very interchangeable, but I don't think that's the intention. So I think the regulator might be looking for some clarity on that. The current term that I believe we should be using at the moment is a higher risk building. And this are those buildings that meet the criteria in those blue nodes there. Firstly, there needs to be a height requirement that's satisfied. So they are buildings, residential buildings that are 18 meters or above, or have 87 stories or more. And as I said, that residential element of involving 2 or more dwellings units. And this applies to both new and existing buildings. Those 2 criteria apply, then a high-rise building is what you have. And the information of those 2 other spheres at the bottom, we should point out that firstly, hospitals and care homes that are high-risk buildings will come under the Act, but that's only during design and construction, because these facilities are operated in a different way than a block of flats, for example. The occupation elements of the Building Safety Act, which we'll come on to, will not apply. So it's just design construction for hospitals and care homes. And those facilities in the red sphere, as it says, they are not currently included in the Act. But it should be noted that the Secretary of State obviously has allowed a provision to extend the scope of the Act if that is required at a later date. So in theory, these buildings could be brought under the Act. So in practice, just a simple graphic here, just to guess, confirm the height and how it's measured. The height needs to be measured of 80 meters or more, 7 stories or more, from the low side of the building, and it's from the upper floor surface of the top floor to the ground level on the lowest side of the building. Currently, we need to exclude any rooftop plants or upper stories that are solely dedicated to mechanical and electrical plant rooms, etc. Hopefully that diagram just gives a bit more clarity of what the height looks like. And any galleries or mezzanine floors that have 50% of the largest sort of story directly vertically above or below should also be included as a story. So we'll all get used to this term when we apply this to our projects. So that's just the little graphic there on the height component. Then just a brief slide introducing the Building Safety Regulator. The Health and Safety Executive has been named as the Building Safety Regulator and will have 3 main functions. As you can see, they are to provide an overseeing role of all standards across the industry, leading implementation of the legislation itself, and ensuring that competence across the sector is improved. And you'll see some elements of the Act which have already been enacted to help drive those changes. The regulator will be supported by other bodies. There's a few there: the Building Advisory Committee, the Interim Industry Competence Committee, and the Statutory Residence Panel. So there are going to be 3 key, if you like, arms of the regulator. Will be providing input, advising the regulator, and actually, and act as almost like a sounding board of industry, and just act as a feedback channel between the industry and the regulator. And I should also add at this point, the regulator is going to have some serious enforcement tools at their disposal. So it's going to be really important to ensure that all duty holders and those involved with any project are actually working hard to discharge their duties. And we have to assume they will not hesitate to bring those enforcement tools to bear should they feel that's necessary. Okay, this slide just covers a little bit more around the gateways, which I mentioned a moment ago. There are 3 gateways. One is a planning gateway 1, and as the title suggests, that is applicable at planning stage. And then we have gateway 2 and gateway 3. We understand there's an approximate period of 12 weeks, 3 months to allow for each gateway to conclude. And it will normally conclude as by way of a document or an application pack being submitted to the relevant body that gets reviewed, assessed, and as you can see from gateway 2 and gateway 3, they are known as hold points or hard stops in the process, and works or the project cannot proceed past those points until approval has been given, in this case by the Building Safety Regulator. Applying gateway 1, which we'll come into in a moment, a bit more detail, a fire statement is needed. So this part is slightly separate from gateway 2 and gateway 3 because a Building Safety Regulator approval is not needed at this stage, because this is the plan application stage. So this will be submitted, the fire statement, along with the plan application to the authority will be approving that application. And then the design will proceed into gateway 2, where, as I've said, works can't proceed until the relevant part of that design has been approved by the regulator, and so on. And there'll be obviously additional requirements introduced during the construction phase prior to gateway 3 being the gateway 3 application pack being submitted. So we'll just dive into each of those now in a little bit more detail. Plan gateway 1 is the requirement for a fire statement. This became live from August the 1st, 2021. So if any projects had not been plan application had been submitted before that date, then the fire statement is applicable. And even if any projects with ongoing planning development is proceeding now, then a fire statement needs to be compiled. It basically provides information on the fire safety matters related to the planned land use. So it's just making sure that the project team are thinking about those early approaches and conceptual design stage about how that building needs to be orientated, providing sufficient access to obviously emergency vehicles, fire rescue service, a consultant is necessary, the HSE consultant is necessary through a free pre-planning service, and any local fire safety policies are actually picked up. So it's a form that needs to be completed. There's a template available, which the Secretary of State has prepared for use, but it's not the only way. Other forms can be used, but as long as it covers the same substantial information. This is then compiled by the project team, submitted as part of the planning application, and approved as part of the plan application. And the 12-week period that we've been told to allow for Plan Gateway 1 can, we understand, run concurrently to that plan application. Okay. At Gateway 2, this is where the information is in the design has continued to proceed. This Gateway 2 replaces the building control deposit at plan stage before building work starts for high-risk buildings. Remember, this only applies to the high-risk buildings. As I've said, the regulator will have strong enforcement tools where building work commences without first obtaining building control approval. So at this stage, this is the opportunity for the project team to actually pull together a design that really does meet the brief. The brief being a compliant, safe building. So we understand it needs to ensure that the building regulations are obviously complied with, but this needs to be done better than industry has done it before. So a holistic view needs to be taken, making realistic assumptions about how the building will be used, maintained, and accessed by all bodies, authorities, and so forth. But it needs to be done now and not allow design creep to proceed. Lots of valued engineering, etc. It needs to be do as much as you can now front end. I think the regulator would support that view. We know it's not always going to be possible, but the intention is to try and drive that early front end design and get that approved. If there's a design and build approach to be taken, then we understand at this stage a design and build approach statement would be needed just to declare that the project intends, or the developer intends to proceed on that basis, and we understand the regulator will permit that. But each package that gets compiled will need to be submitted and approved before the construction work for that package actually commences. There's going to be other things that need to be in place at this stage. That'll include making sure the team is obviously properly competent for that particular building. Make sure the golden thread of information, which we'll come on to later, is being collated and managed and can be managed through the rest of the design process, the construction phase, and into the occupation phase. There's been mandatory reporting needed. An arrangement will be needed at this point to capture if significant safety or fire or structural safety issues occur during the construction or into occupation, that there's an arrangement in place to capture that information and share it with the regulator. And that the construction phase itself will be compliant, and how change will be managed on site, and the arrangement needs to be captured at this stage to make that clear. And then, as I mentioned with the stage plans, we understand that's how they will allow stage 2 information to proceed past this point. So if an enabling package is needed to understand more about the ground makeup, or on access routes, etc., then that information will be collated, submitted. The information is gathered from site and then plugged back into the design, and you go again for the next package. Building safety levy. This is something that's been talked about a lot in industry. We understand that it's part of that building safety regime to ensure that basically industry pays for the mistakes of the past. It's to partly fund the building safety regulatory activities and programs, it says there, but to really help provide the cost that's needed to remediate the problems. It's going to be applicable on all developers of new residential developments, requiring building control approval, regardless of height. It's understood that the levy, unless it is paid, that project cannot proceed, which of course could accrue project delays. And of course, this is going to be another cost on other costs which will be levied to the developer. So that in theory, the whole design could be ready, oven ready to go, approved by the regulator, but until that levy is paid, that project would not be able to proceed. It's understanding that it's designed to generate about 3 billion over the next 10 years. It's run alongside the other developer pledges you certainly may have heard about in the press recently, such as the home builders developer pledges, which are committing to affix life critical fire safety defects in buildings over 11 metres. And I think Michael Gover's got almost a full house on that now, but I think there might be a few still looking to sign that contract, hopefully. The levy is designed to ensure leasehold protection, regardless of any developer pledge. So it's not dependent on anything else. And clearly it's going to increase overall development costs, but it's just waiting for the actual details of that. So we understand that the Gateway 2 will be introduced from October the 1st this year, and the building safety levy is attached to that. So because of its purpose, which is to make sure the funds are provided up front, they've obviously twinned it with the Gateway 2 approval. So once the design's ready and the levy's ready, then works may proceed. If you go back to the screen with the 3 gateways and that blue bar at the bottom between Gateway 2 and 3, this is relating to that section. And this is where we've got additional requirements on the project team that will need to be met during construction. So there needs to be a very robust design change control process in place. So as I said, that the focus should be on minimize the amount of change that's needed. We know in the real world, there's usually inevitable change. So we just need to be able to capture that change and manage it better, demonstrate its impact on the wider project, and also any enabling design passages which might be related to it. We understand once that change is identified, it may constitute either a major or a minor change. We're waiting for the definition on that, but it's understood that if it's a minor change, the submission is made and the regulator has 10 days to maybe 10, 12 days to return any comments. And if no comments are received at that time, then the design can proceed. But if the change is classified as a major change, we believe that could take maybe up to 4 or 6 weeks for the regulator to review, approve before works can proceed. So works, that last point is really key, must not proceed before reapproval in writing. Or unless that period has elapsed if a minor change. So it's one of the changes that we need to be really clear on as we're going forwards. So hence why the regulators encourage as much to be done at Gateway 2 to cut down on the delays, which of course would be inevitable, and potential fines if the regulator felt that any elements proceeded without their approval. So at this stage, this basically occurs at the current completion final certificate stage when relevant building work is complete for high risk building. So the construction phase is come to an end. If we understand again, a stage approach could be or will be allowed. So at this stage, this is where the whole Building Safety Act really needs to come together. We should now have a safe, holistically safe and compliant building, which meets all building regulations. So during this 3-month assessment period, the regulator will obviously be inspecting to make sure that the as-built structures and features asset actually reflects the approved design, and that obviously meets all building regulations. We need information at this stage to help manage building safety risks when the building is in use. So again, the fire and emergency file needs to be duly populated with relevant information that the owner or occupier, or I should say the operator of that building, can use and introduce and is able to introduce before the building's occupied. Proposals for a phased occupation is to be agreed at design stage. So if you remember those statements I talked about, if that is the case, a phased occupation stage would need to be agreed by the regulator at Gateway 2, and then at this stage they'll be looking for the relevant information to be compiled for that element before giving sign off. And then once the regulator is happy, the completion certificate can be approved either for the building as a whole, or if they do allow a stage approach for that respective stage. And at this point, we just need to remember this is before the building can be occupied. So construction work will complete, then there needs to be around, yes, like I said, about 3 months, 12 weeks in which the building cannot be occupied. And once that completion certificate can be issued, and the next step, which is the registration, then we can look to occupy the building. So it's important to allow for that period after construction is completed, but before occupation. So just a brief summary slide here, just looking at those gateways, beg your pardon. Working from left anti-clockwise in a nutshell. During design stage, the regulator will be the building control authority for high-risk buildings. As I've said, they need to be safe, holistically safe for those who build them and use and live in them. Industry needs to do a better job of demonstrating compliance with building regulations right from design through construction and obviously into occupation and onwards. Design change and change management generally needs to improve. So this needs to be captured. How are you going to do that design? We need to make sure that the right project team is assembled and is maintained, because obviously as people come and go from project teams or organisations, they need to be replaced with similar competence to make sure that that project team isn't affected, and that the golden thread of building safety information captured early on is actually stays through, as the golden thread suggests, through construction and into occupation. There'll be a bit more on that later. And then construction commences, but only for packages that have been approved. There will be site inspections, key milestones which are agreed again at design stage. So they'll be followed through at construction phase. The mandatory occurrence reporting I touched on. This has to be demonstrated through construction phase also. So should, for example, a slab collapses during the build, I would suggest that would need to be captured, or I should say would meet the criteria that would need to be captured and then reported to the regulator. But we're still waiting for a bit more information on what those type of instances, safety occurrences would look like. Again, continued change management through construction, and noting some may require further building control approval, so allowing for that potential delay in the project, and again, maintenance of the golden thread of information. And then at completion, as we've just touched on with the last slide, this is that final assessment by the regulator to ensure the building regulations have been met. The building or the installed features represent design that's been approved. The documents which are needed by the owner to occupy that building and operate the building correctly are available and been provided. And at that point, a completion certificate can be issued. And then the building needs to be registered with the regulator. And of course, this is where there may be a delay if there are any problems with any of the previous stages, should the regulator decide that the finished structure doesn't yet represent what was agreed, and some remedial work may be needed. So there's a potential for delay at that stage. But as I said, we do also believe that they will allow for a staged approach to completion. So just a bit of a summary of the gateway process there for high-risk buildings. Okay, moving into the occupation stage. We touched on some of these duty holders earlier. One of these is the accountable person. Now, this is not to be confused with the responsible person under the fire safety order. The accountable person is typically going to be a landlord or a freeholder who is in charge of repairing the common parts of the building, including the exterior and the facade of the building. Now, this could be an individual, could be, let's say, a corporate body, a partnership, but what is clear is they understand that their duties must be fulfilled. and they are to comply with the safety case report, which we'll come on to shortly, and the mandatory occurrence reporting. So should a critical fire or structural issue incident occur during occupation, they must ensure that that information that's needed is captured and submitted to the regulator. The AP must also conduct an assessment of fire and structural safety risks, make sure that the residents remain the heart of that building, and changes that occur are effectively communicated and basically consulted and involved. So therefore, a residents engagement strategy is needed. And by doing so, the next point will also be satisfied, which is to make sure they are given the relevant safety information that they need. And of course, it's got to be in the right language and format so they can actually understand it and get involved with the management of their own building. And equally, vice versa, they need to understand that they've got duties back to the building and the AP, such as, you know, the importance of fire doors. In fact, that's captured in one of the other pieces of legislation. So they understand that doors should not be, they obviously have a real purpose, shouldn't be propped. So it is a bit of a two-way street here to make sure that residents are duly informed about their building, and make sure that they maintain the building safety information and the golden thread. As changes come on, as new packages or extensions are come on with the building, or even, you know, parts of demolition removed, that golden thread information needs to be managed throughout. And ultimately, to take all reasonable steps to prevent a major incident. So if they see a problem, it's got to be acted upon. They're the duties of the accountable person. Now, they're not to be confused with a principal accountable person. Now, this person comes into force where there's a building has more than one accountable person. It'll be the accountable person that's responsible for the structure and exterior of the building. Now, they'll be the principal accountable person. If there's only one accountable person, they automatically become the principal accountable person. So we therefore have all the duties of the accountable person, in addition, the following ones also, which are to register all new high-risk buildings before occupation. They'll have to prepare a safety case report, which is what the accountable person must ensure is they obviously comply with. It'll be the principal accountable person who actually compiles that for the building and then submit it to the regulator on request. Equally, they'll have to apply for a building assessment certificate when required by the regulator. And then, as I said, with the registration of the buildings, make sure that all existing buildings are registered, as well as the new ones. Now, the portal for the regulator's building registration portal opened on the 12th of April. So one of the principal accountable person's duties is to now start acting on getting any existing buildings, of which we think there could be around 12,500, even more, they need to be registered before October 23. So it'll be offence for any building to be occupied that's not registered after 1st of October 23. So the principal accountable persons will obviously now need to be appointed, and they've got, like I say, these this period between the 12th of April and the 1st of October to get all buildings registered. Now, we don't think the information is it's terribly onerous on the regulators' pages themselves. They said only basic data is needed, including the address, height of the building, number of flats, information on the accountable person, the principal accountable person, and any other critical or key people that might be involved in the management of that building. So it's a portal you go on, which is now, like I say, open. You can upload that information, and then from October, it'll obviously capture all new buildings as well. After registration, what the principal accountable person will then need to do, and that it will be to apply for a building assessment certificate, and that'll be on direction from the building safety regulator. In order to get the building safety certificate, some of the terminology we've already used before will need to be submitted, such as the safety case report, the mandatory occurrence reporting, and the residence engagement strategy. We think for new builds, which will apply from October the 1st going forwards, this information will need to be provided within 6 months. And then once that assessment has been certificate has been issued, we think then it'll be on a 5-year rolling program, depending on obviously the risk of the building, but also probably performance as well. So if you are a safe compliant operator of a building, then it's typically we think be a 5-yearly review of that building assessment certificate. Depending on your risks, it may be greater. So there are, you can see there are a number of tasks that need to be completed, duties that which will be quite onerous for the principal accountable person and accountable persons. We've touched on this a few times now. It's the safety case and report. They are two separate things. The safety case is basically all the information you need to manage the building, the risk of fire spread, the structural safety of your building, preventing obviously those things from occurring, fire spread and structural failure, and also limiting their consequences. So that little graphic we've included there as a it was actually extracted from one of our when the assignments from one of our colleagues during the diploma I touched on at the beginning, where you just need to show in very simple graphic form, typically graphic form, use of QR codes, etc., the kind of information that needs to be collated and shared with residents and contractors in the building. It could be displayed in foyers, for example, just to show how the building and why it is safe to occupy through various links. It would take them to the fabric, the external wall makeup, evacuation procedures, etc. So again, it's just giving that information, which hasn't been ever done before, to those who will be living and working in the building. But it's obviously tailored to the building, so to avoid any duplication and just copy and sharing from from previous templates. It's got to be tailored to that building, and as I've said, submitted upon request. The safety case report is a document that basically summarizes the safety case. So it identifies your building's major fire structural hazards, how you're actually managing the risks of those, and basically just to give some confidence that that the building is in safe, good hands and is being well managed. So that's what the regulators will be asking for, along with the engagement strategy and the mandatory occurrence reporting arrangements, at least as a minimum. There may be additional requests they make. It's just clear to point out what the safety case report is a series of individual reports. It can't be full of technical jargon, or be overly complex. It's certainly not something you do once off and then you put it on a shelf to get digitally dusty. It's something that's got to be reviewed and it's got to be kept refreshed. So this is something that these new duty holders will be getting to grips with, and industry as a whole. Okay, I've touched on this enough now, so I'll now talk about the mandatory occurrence reporting. In a nutshell, as I've said, there are certain instances which the regulator will need and want to know about. We understand these will be typically fire and structural related, but basically safety occurrences of an order that the regulator thinks, well, if that's happened, we need to capture information and share it. If it occurs during construction, we understand a member of the project team will report that, whether that's the principal designer or the principal contractor. And then at occupation stage, it'll be the principal accountable person who will need to capture and report those issues to the regulator. And we think it's going to satisfy some of the following. It's to capture obviously risk and performance data, but also to drive intelligence-led enforcement. Obviously, with the ultimate goal of actually promoting safety conscious culture change. So if that slab fail was to be captured and shared across industry, obviously the regulator is expecting that lesson learned to be incorporated into procedures and arrangements for other projects and within organisations, and also just to improve the safety standards and best practice across the built environment. So that goes back to one of those spheres of the regulator, if you remember at the beginning, about why the job is to basically raise standards. This would be one way of doing that. Other changes which are due will include a revised Architects Registration Board, which basically gives new powers to monitor and assess the competence of architects. Another register will open, we believe, from October 23, in which architects, if they wish to continue to practice, will need to be on that register to demonstrate ongoing professional development, etc. Anyone who doesn't comply or fails to, or even registers and then demonstrates non-compliance could be removed from that register and therefore unable to practice. So this is just part of that general trend to actually drive up improvement and professionalism across the sector of those who are working on high-risk buildings. But it's also to actually give public some more confidence that, again, not just picking on architects here, but basically that those who are involved in these high-rise risk buildings have that capability as individuals and as organisations to be doing so. And as I mentioned, there'll be disciplinary orders of anyone who fails to register or doesn't comply with the requirements once on the register. A couple of other changes you may have picked on from the press or industry. That is there's going to be a statutory list of safety critical construction products, which will be available to use on projects to make sure that products that are being duly tested and approved for use to enter the list can then be used on projects. So there's going to be much more of a big drive on manufacturers to make sure that products they produce are duly tested with all the appropriate information and documentation clearly available and sent to industry, so they can be, understood, specified as needed, installed in projects, and then obviously fed into the health and safety file and other handover information at the end of the project. So this is called Construction Products Registration, and the National Construction Products Regulator will work in tandem with the Building Safety Regulator. Will be working on that list of products. But there'll also be other changes to the building regulations. There'll be a ban of combustible materials in the external walls of buildings. Secure information boxes in blocks of flats with over 11 metres. That's make sure that the fire rescue services will have all the available information they need on arrival at an emergency. And these evacuation alert systems, blocks with storage over 18 metres, again to allow the fire rescue service to talk to an individual flat or a set of flats, a floor, or the entire building. So there's a lot of change on the foot at the moment. And there's also ongoing consultation. Some major changes, which you'll probably tell from that list, could have a big impact on the industry. Some of those include the recommendation of sprinklers in new care homes, regardless of their height, the removal of the national classification system currently in use for construction products, requiring products to be tested to the BSEN standards, and buildings above 30 metres to have 2 staircases. And even that last one there is contentious because there's a lobby, I believe, in full motion at the moment, challenging the 30 metres being too high, and instead it should be 18 metres. So all residential high-risk buildings of 18 metres above should have dual staircases. So there's a lot of moving parts in the background. This is this is why they're also consulting to get industry's feedback. And then lastly, a call for evidence to determine the materials and products used in external walls. So again, that feeds into the classification of products and the register I mentioned to make sure that we can't build another building similar to Grenfell where fire spread can occur as it did then. So it's all positive, but these are just some of the changes which we understand are in motion. In addition, there are fire safety legislation which has been enabled as a result of the Building Safety Act. Just taking the Fire Safety England Regulations 2022, for instance, which was introduced as part of that tighter building safety regime that's now in force. Came into force on 23rd of January 23 with a number of requirements. And they are that the responsible person, which is different from the accountable person, of course, responsible person coming under the fire safety order, the regulatory reform order, they must ensure that for those multi-occupied residential buildings over 18 metres, that they share electronically their information with the fire rescue service relating to external wall system, copies of floor plans and building plans, keeping a hard copy of the floor plans, and then providing the contact details of the RP, the responsible person, sorry, in the secure information boxes just mentioned, so they're accessible to the fire rescue service on arrival. Installing wayfinding signage, which is visible in low light conditions. Establishing monthly checks on the lifts and any other firefighting equipment to make sure they are effective and usable during an emergency. And that if any lift to be used by firefighters or any other piece of equipment is out of order for longer than 24 hours, then that needs to be informed, that the rescue service needs to be informed of that. These are very sensible, pragmatic changes, but they're going to be obviously now enshrined in law to make sure that they are built into projects. So there's going to be new legal duty for responsible persons to undertake fire risk assessments to make sure that includes flat doors and doors in the communal areas, and of course the external wall system as well as part of that fire risk assessment process. Also, these changes are going to be making legislation so that there's more greater accountability of the responsible person, the accountable person, and of course the principal accountable person. So we talked about accountability at the beginning. This is what it looks like in practice. That's why this enabling legislation has been introduced. And as you see there, that last one there, the middle one on the right, buildings over 11 meters. We're still going to have requirements to, well, this isn't in force now, requiring annual checks of all flat entrance doors and quarter checks of all fire doors in common areas. And this again speaks to that part on the resident engagement strategy to make sure that residents do understand the purpose of fire doors. So it makes the life of the residents safer and the contractors who are using that building or work in that building, but also the accountable person, those who are occupying and operating the building, their job easier and allows them to discharge their duties correctly.
Hi Dan, you've just got about 7 minutes left, sorry.
Okay, great, thanks. Thanks for that, Bella. And then just some other changes we just wanted to touch on. One being that we've already touched on the competency across the sector needs to go up across the piece, in particular for high-risk buildings, but also that building control inspectors must be registered from October the 1st onwards. And that register, we understand, will be open for 6 months. Anyone who is wishing to continue to practice as a building control inspector or approver needs to be on that register. Again, that's just part of the profile of raising the competency across the industry. And part of that is that going forwards, developers won't be able to select their own building control body. It's part of the levelling up agenda between the private and the public sector. And also the Defective Premises Act has been enhanced to pick up defect periods for 11 meters in blocks of 11 meters or more, or at least 5 stories, whereas previously it was 6 months, 6 years. So retrospectively claims to be brought forward. That's now been brought up to 15 years going forwards. So anything that's built, claims can be brought to 15 years. And then retrospectively, it was 6 years, that's been extended to 30 years. And again, this is linked to that developer pledges you talk about, fixing those safety critical performance issues in buildings in the past. So it's part of that agenda that the government want industry to pay and repair for making good problems from the past. Just a couple of items there on other funding and requirements that the client will need to, developer need to comply with. One will be the residential property development tax, again, which goes towards the costs of repairing unsafe cladding. We understand it'll be the largest residential developers who have to contribute towards this, to these funds, and they'll be taxed at a charge of, we think, 4% for the large developers with annual profits in excess of 25 million, and that's designed to be, raising about 2 billion over 10-year periods. But we understand it will be time limited, and it will be repealed once its aims have been achieved. So there's some of the costs we're talking about, which our current clients, developers, and your own need to be aware of what's coming. And they'll also be expected to join a new homes ombudsman scheme as part of that residential resident drive to make sure that they can feel confident and safe to bring complaints or issues to developers, and they'll have to respond obviously in a timely manner to make good of those problems. And there will be sanctions for breaching any requirements. So code of practice will be developed. The developer will have to obviously work in accordance with that, and as I said, could be sanctioned failing to do so. So adding more protection to that homeowner. As we're just coming into land now, I just want to just touch on some of the implementation of the Act. We've seen with some of the previous slides that the governments are on track, as this timeline suggests, from when the bill was introduced. It achieved royal assent last April, and we're currently at this stage here, 12 months on, where they've introduced the resident panel, changes to the construction products regulator, the limitation period has been extended for the defective premises that we just touched on, changing the fire reform, regulatory reform order. So that's all in plan. Now, between April and October, the next 6 months, a lot of the big weighty items are due to come online, which is such as the gateway system from October the 1st, the new duty holders of the accountable person and principal accountable person, which of course is now live because the building registration portal opens from this point onwards. So they are on track of delivering the legislation change that they announced last year. Here in RLB, we just thought we'd just quickly summarise some of the key stages, I guess. At this stage, we just need to make sure that on all our projects and your own, that you're complying with the building regulations, and that the right team is working on a project, and that fire statements are submitted for Plan Gateway 1 on applicable projects. At this stage here now, April 23, where we are, you can see the changes to the Architects Register and secondary owned powers to enable the construction products regulator to enhance the powers there. And then from October 23, the ones I've just touched on are all coming in force. The golden thread, details of the principal accountable person and the accountable person, etc. Oops, sorry. And then lastly, from April 24, we understand the regulator will start to call in buildings for assessment, for those building assessment certificates we mentioned, and in ensuring that the building inspectors and building control approvers, because their register will have closed, that they are now working actively in accordance with the new their new requirements. There's still a lot of unknowns. There's just a few there, just to give you a bit of a sample. We don't know all the answers to these yet. We're just waiting for more information to come out. We understand the regulator will give industry 3 months. I picked up on yesterday before a new secondary legislation becomes available. So 3 months isn't long. So the more ready we are in all the other aspects, industry can turn to those changes, understand them, and then implement them on projects. This slide pretty much sums what we've been talking about, how the Building Safety Act, which was actually structured on the CDM regulations, will be running in parallel, as they both are have shared aims of transforming culture, a risk-based approach, early stakeholder engagement, and clear information flow from cradle to grave. And the golden thread of information is critical here to make sure that the information that's captured during design is passed through structure during construction and into occupation, making sure that this is the single source of truth for how safety information needs to be captured and used going forwards. So just to finish with, it's a question really to yourselves. Do you feel prepared? The regulators made a Making a Building Safer campaign available. So I would implore you all just to have a look at that. It says there, read on the slide. Be ready, step up, and act now. Industry has been a bit slow to begin with, I think, last year, but now the regulator's seen a lot more movement. So this is our chance to really do engage with the information that's available. So you can just see the little link at the bottom if you wish to make a note of that. But a copy of the slides will be shared with you afterwards. So it'll be on there. That's just a slide just to summarise it as RLB, because we are on that signatory, we're a registered signatory of the Building Safety Future Charter. This is kind of what we've been doing in the background to make sure that we are reviewing and upgrading our systems in line with these 5 big building blocks, key commitments, which are required for the register. And that we're taking the opportunity to obviously review and basically provide a whole new set of services to support clients and the wider industry with all these new requirements. And then this last slide is just really touching on a partner that we've worked with and are working with called Operants, who have developed a new system of managing information on a digital platform, and we're just partnering with them to make sure that information can be captured and managed on projects going forward to help the operator provide all the information that's needed to meet the requirements of the Act. And I think that brings us to a conclusion, Bella. So hope this has been some use. I know it was a whistle-stop tour. Just please remember it is an overview. There's a lot more detail out there, and with more to come as the second legislation begins to get unlocked. So if there's any questions, I have to stay on for a bit, or put them in the chat and we'll just see where we go from there.
Thank you so much, Dan. We do have a couple of questions. We will stay on until about 1:15, and if anyone would like to send any more questions through, please do via the link, and we'll do our best to answer them in the time. So the first question is from Eleanor, and the question is, with the building levy coming into place in October 2023, if your client is planning to have planning approval and due to commence on site in September 2023, would they be subject to the building levy, or is the levy only coming into effect on developments which commence on site after this date?
It's a great question, Eleanor, and it's one that I think we're all looking for some real clarity on. But as we understand it, if the design of planning application has been submitted and works can start within 6 months from October the 1st, which obviously needs to be recorded in writing, we understand that the building can proceed under the existing arrangements. That's in terms of the gateway process. In terms of the actual levy itself, I would suggest also the same, but we just need that confirmation. So I can't confirm one way or the other, I'm afraid. But we understand if construction can start within 6 months from October the 1st, then works proceed under the existing arrangements, which seem fair, but they may just use it as a drop date and say no matter wherever the project is, the levy is going to be due. So sorry I can't provide any more clarity at the moment.
Perfect, thank you. Our next question is from Alec, and the question is, to undertake a survey for buildings over 11 metre in height, what kind of costs are we looking at for clients / building owners?
I'm not sure what surveys Alex is referring to, whether that's like measured surveys, do you think, or could it be structural or fire surveys? I guess
not specified.
I guess just Alex, sorry, I can't be. I'm not sure about the entire scope of your question, but I think the main thing to just remember is that should any construction work be needed as a result of that survey, and the building is even if it's not a high-risk building, we just need to make sure that those surveys do capture the latest fire safety legislation, and obviously building control measures, which will be picked up by the Building Safety Act. So, in a nutshell, although the gateways won't apply to a building above 11 stories, but below 11 metres, but below 18, a large chunks of the Building Safety Act will still apply, such as the building control, such as that competence of the person, I guess, doing the survey, and any enabling works by contractors working on the buildings, and make sure that the fire risk assessment picks up the new requirements as well regarding the external wall. So I hope that might be some use. I'm not sure.
I hope so. Our next question is from Dean, and it's, how does this impact buildings currently under construction and due to complete after the 1st of October?
Thanks, Dean. I think as per my answer to Eleanor, we think that it won't be impacted if works are currently underway, and they'll just be completed under the existing arrangements.
Perfect. I'm sure that's the answer he was maybe hoping for. Our next question is from Christina, and it is, would sui generis co-living be subject to the BCSA 2022?
I couldn't hear what code, sorry?
Sui generis. Christina, could you just clarify what you mean by that in the chat, maybe? It's co-living spaces, so I assume it means just co-living spaces within apartment buildings or thus like.
Yeah,
Maybe we'll go on to the next question, Christina. If you could clarify that question in the chat.
Yeah, or drop it to the administrator after. Happy to pick it up as a as an email if anybody wants any information after. But yeah, I'm not sure. I don't understand the question. Sorry. There's another one about it.
Our next question is from Henry, and it is: would any type of refurbishment work require notice to the BSR? Sorry.
Anything that requires building control approval, yes. And if that building's over 18 metres, yes. That the building safety regulator is the building control authority.
Okay. We've had a further clarification come through from Christina saying that the sui generis is the use class of the co-living. I'm still not 100% sure on this. It seems like quite a specialist area of
yeah, where that's maybe or like the product classification system we talked about. Maybe it's linked to specification. Yeah. Same response. If she wants to drop a expanded question, and we are happy to look at it afterwards if that'd be of any use.
Okay, perfect. And that is all of our questions. Unless the event organizer can confirm that we have any more, I think that that's everything. Okay, we've had no further. Hang on, we've got one more that's just come in very last minute. Okay, it's a clarification from Christina. So she was wondering if co-living buildings will be treated as residential or hotels in this case. So that was the question. Will they be treated as residential properties or hotel type properties? Co-living, yeah.
Yeah, I'm not sure.
So I think it's almost like, I suppose it's similar to student accommodation types where you have shared kitchen or bathroom spaces and then individual bedroom.
I'll be honest, that might be just me. I just haven't come across that phrase before, co-living. So yeah, I can't without knowing what the phrase.
That's fine. It's not something you've worked on before.
That's wrong of me to try and to give an answer. Sorry, Christina.
Yeah, Christina, maybe if you pass on your email address to the event organizer after this, we can do some research on that and get back to you with a little bit more detail. Yeah. Okay, perfect. So I think that's all for the questions for today. Thank you everyone ever so much for joining us, and a huge thank you to Dan Cooke again from Rider Levett Bucknall, Senior Associate in Health and Safety. If you would like any further information on this or any advice or surveys or information on the Building Safety Act, please do reach out to Dan or Rider Levett Bucknall, and we'll be able to direct you to a suitable person to advise and provide services. Thank you very much, and the Building Safety Act slides will be shared with everybody following this call.
Great, thank you everybody for listening.
Thank you. Bye.